Item 6.
Item 6.
Yes, yes. This person is not responding to anything, not letter, no letter, not responding to letters, calls, nothing. I have no communication with him.
So
I would like to withdraw my vocal. I'll place the records. I would like to withdraw my vocal.
then you write to the registry and
Very well.
6, you write Mr. D. Bhattacharya, learned counsel for the petitioner, submits that he has lost contact with his client and the petitioner is also not in touch with him. Stop. As such, he seeks leave of this court to withdraw from this matter by following the due process. Leave granted. Mr. Bhattacharya may do the needful by following the usual procedure. This matter will be listed again after 6 weeks with appropriate office note. Yes.
May I please your lordship? It's an FT matter, so we have for listing. Tomorrow the person got detained.
When?
Tomorrow?
Next week, before next week, there will be no listing. If you want it next week, fine. Otherwise, you have to mention it somewhere. These days, we will be completely on the series partner matter.
He got detained.
Monday. Yes, next matter, please. Monday.
Monday.
Maybe this lordship, I recommend for listing WBC 345424.
Tuesday.
Please, your lordship. Lordship, I beg to mention item number 7. Lordship, kindly matter may be passed about for the day. Yes, the advocate for the
On the prayer counsel for the petitioner, this matter stands passed over for a week. List accordingly.
Please, your lordship. I beg to mention item number 2, lordship. In this case,
Item number
2, lordship. In this case, you want to withdraw a name from Ukalat number, lordship. We already intimate the client, lordship.
This article, counsel for the petitioner submits that the engaged counsels in this matter, including herself, would like to withdraw from this matter since the petitioner is not in touch with them and therefore raise for 2 weeks time to do the needful. Prayer allowed. Let this matter be listed again after 4 weeks with appropriate office note.
Lordship, I pray for listing of a finance matter, your lordship. On Monday, your lordship, for motion.
Daily list for motion item 1.
Matter.
Okay, then we can go again. It's not done anyway.
LCR has been received. What to do? One more chance?
Yes, for the class ones.
None appears for the writ petitioner when the matter is called up. Mr. J. Pine, Leonard SC, Home Department, Government of Assam, and FT Department. Mr. H.K. Hazarika, Leonard G. Assam. And you are for the Government of Assam.
Madam Deputy Commissioner.
Sorry?
For the Deputy Commissioner. Please.
G. Assam. As well as you are appearing in this case.
For Indian India, lordship.
As well as Mr.
DJ Das.
DJ Das, Leonard CGC are present on behalf of the respondent. The LCR as called for by this court has already been received. However, since the petitioner's counsel is absent today, this court is left with no option but to adjourn the matter for 2 weeks so as to give the petitioner an opportunity to pursue the matter. Register to list this case accordingly.
For admission item 3.
Now appears for the petitioner on call, Mr. So-and-so are present on behalf of the respondent. Since the petitioner's counsel is absent today, this matter stands adjourned for 2 weeks. Interim order, if any, to continue. The counsel is absent today. So as to give one final opportunity to the petitioner to pursue the matter. We adjourn this case for 2 weeks. Interim order, list again after 2 weeks. Interim order, if any, operating in this case shall stand extended till the next listing.
Item 4.
None appears to be petitioner or call. So and so, so and so, so and so are present on behalf of the respondent. Since the petitioner's counsel is absent today, this matter stands adjourned for 2 weeks. List again after 2 weeks. Interim order, if any, operating in this case shall stand extended for till the next listing.
Item 5.
May please, your lordship.
Yes.
Lordship, implement order page 44, my lord. Annexure 7, my lord.
This is a contested case.
Contested case, my lord.
All right, heard Mr. Your name please?
Z Ahmad, my lord.
Zaid Ahmed, counsel for the petitioner, also heard so and so, so and so, so and so, appearing for the respondents. His read petition is directed against the order dated.
Page 44, my lord.
Order 26/4/2017 passed by the learned member FT number 5 Morigao in connection with FT bracket D bracket close 514/2016 declaring the petitioner as a foreigner of post 1971 stream. First up, it appears from the materials on record that it is a contested matter. First up, the LCR as called for by this court has already been received. First up, there is consensus at the bar that this matter would require full-length consideration. As such, admit the read petition. Since the parties are already represented, no further notice is required to be sent in this case. Registry to list the read petition for hearing in usual course by taking the LCR.
Interim may kindly be continued.
Interim order passed here.
My lord. I'm deeply obliged, my lord.
Hearing item 8.
Hearing no কৰিব ন?
Hearing will not do it. First, the part heard matters. So you can have it next week if you want. Any date will, yes. In the request of learned counsel for both the sides, this matter stands adjourned for a week, list accordingly. Bless you.
Item 9, 10, 11, 12, 13, 14, up to 18.
Yes,
May it please your lordship. So in these batches of cases, lordship, basically they have challenged the overall act. So I'd like to place the act. What is the overall scheme in this act? Because in piecemeal basis, the other side is placing the provisions. But what is the overall scheme and how government wanted to provide the benefit of regularization of teachers? That we have to see. And in the while doing so, I will clarify also certain queries which was raised by this honorable court on the last occasion.
yes.
So if lordship is pleased to take up this particular act, Assam Education, Provincialization of Services of Teachers and Reorganization of Education Institutions, Act 2009-17, we have to see the preamble and the very relevant provisions which are part of this adjudication. So if lordship is pleased to come to the preamble part,
Yes.
it is an act to, there are three objectives of this act. It is an act to provincially, and if lordship is taking the same book,
We have a compilation of our
Oh.
own.
an act to provincialize the services of the teachers of venture educational institutions and to reorganize and streamline the educational institutions up to degree level in the state of Assam. Preamble. Whereas it is expedient to provincialize the services of the teachers of venture educational institutions and also to reorganize and streamline the educational institutions up to the degree level in Assam. so as to conform to the prevailing statutory norms and standards with a further objective to restrict any further growth of such venture educational institution in the state of Assam. So three objectives are there. One is to provincialize the service of the teachers in venture schools. Number two, that all the teaching staff and all the institutions fulfill the norms and standard of the regulations which are in force. And number three, Lordship, to restrict mushroom growth of this kind of institutions. At that point of time, when this act was brought into force in 2011 as well as in 2017, there was no dearth of schools. There was no shortage of schools. RTE norms, everything can be fulfilled by government institution. In our affidavit also, we have very categorically stated. But this is basically a welfare scheme, welfare action of the government. There is no bounden duty, no constitutional duty upon the government to provincialize them. But this is a welfare action. Therefore, Lordship, we have to look this from a particular spectrum. In fact, there is no enforceable right of any of the institutions or the teachers to get provincialization. Now, this act will come into force. These are the normal things. Now, the basic definitions, 2-3 definitions I would like to place. Definition section is 2. There is a concept of base school. So base school means either an existing provincialized or venture educational institutions identified for the purpose of provincialization of services of teachers and or tutors, as the case may be, within the radius of 1 kilometer in case of lower primary school, within the radius of 3 kilometers in case of upper primary school, within the radius of 5 kilometers in case of high school or high madrasa schools, and within the radius of 7 kilometers in case of higher secondary schools or junior colleges, and which possesses satisfactory norms and standards in relation to the enrollment of students, adequate infrastructure, and having DICE code for the year 2009 and 10 or before. So base schools are already provincialized schools or certain schools which can be provincialized, but they have to fulfill the norms regarding infrastructure and other requirements regarding the number of enrollments also. And they must be in the DICE code system from 2019 or prior to that. Then coming to DICE code definition is I. What is DICE code? Because there are 3 criteria on the basis of which the cutoff year has to be seen. DICE code means District Information System for Education Code, prepared by the Sarva Shiksha Abhijan Assam and available in the records of National University of Educational Planning and Administration, New Delhi. So this is a pan-India scope. Then employees, I am skipping all this. Coming to the definition of provincialization P. Provincialization means taking over the liability for payment of salaries, including dearness allowances, medical allowances, and other allowances to the teachers or tutors as admissible to the government servant in similar category and gratuity, pension, leave encashment, etc., as admissible under the existing rules to the government servants serving under the government of Assam. So provincially will cover this, that government will take the responsibility of giving the salary and other admissible dues. Provincialized schools or provincial college means an existing provincialized school or college or venture wherein the services of the teachers and tutors are provincial under this act. Now coming to definition S. State level scrutiny committee means a state level scrutiny committee constituted under section 1210 to cause physical verification of the institutions as recommended by the district scrutiny committee for final recommendation in the matter of provincialization. Then the definition of teachers, tutors are there. Teachers definition, those who comply with the various regulations and eligibility criteria. And tutors, that definition is important. Tutor means and includes teachers, assistant teachers, classical teachers, and other, and also includes lecturer, assistant professor, associate professor, professor, principal, vice principal, demonstrator, headmaster, assistant headmaster, superintendent, assistant superintendent in a provincialized schools under this act who are not eligible for provincialization of their services and whose services cannot be provincialized in the post of teachers under this act due to lack of his, her educational and professional qualification required as per the RTE Act, National Council for Teachers Education Act 1993, UGC Act 1956, and the relevant rules and regulations framed thereunder, and other acts as the case may be, as applicable on the date of provincialization. However, her service is provincialized as tutor with separate terms and conditions to be notified by the competent administrative department. Provided that a tutor shall not be eligible to hold the post of professor, principal, etc., as the case may be in an educational institution provincialized under this act. So they will not become professor. They may be teachers or headmaster of various positions. They may be holding in the venture school. But once they are provincialized, they will come, if they do not conform and fulfill the requirements of eligibility, then they will be considered for tutor. And further in the provisions, we have also stated that they will be given a time period of 5 years from the date of notification of their regular provincialization, that within 5 years, if they comply, if they acquire the required qualification, they will be upgraded to the relevant positions like principal, vice principal, teachers, demonstrator, whatever position they are qualified. And if they do not fulfill within 5 years, then their whole life they will continue as tutor. So 5 years handle is given to them under the scheme. That's why I'm placing the whole act.
Is provincialization a defined expression? What
Yes,
is provincialization?
Yes.
Is it defined under the act?
yes, it is defined. P. Provincialization means
Hmm.
P. Provincialization means taking over the liability of payment of salaries, including dearness allowance, medical allowance, and other allowances to the teachers or tutors as admissible to the government servant of similar category and gratuity, pension, leave encashment, etc., as admissible under the existing rules to the government servants serving under the government of Assam. And for the tutors, a separate notification was issued subsequently. And in the act itself, the tutors will get, if Lordship is pleased to come to page, the schedule. Fixed salary admissible to tutors. In the schedule, it is there.
Yes.
So category of degree college, the principal will get first and second year 36,000, next year is 40,000. That way, all the positions are covered. In this act itself, in the schedule, we have given the amount they are going to get. So assistant teacher in lower primary school is minimum is 10,800, and from the 3rd to 5th year it is 12,000. So now coming to the provisions of this various definitions of like venture degree college W. Venture degree college means a degree college imparting education beyond higher secondary stage, established by the people of the locality prior to 1/1/2006, because this cutoff date is everywhere. Everywhere it is repeated. And I will stretch upon this. Established by the people of the locality prior to 1/1/6 and has also received affiliation. So they must get affiliation or recognition or concurrence, whatever is required in the particular category of institution, and also receive affiliation from the concerned university, concurrence from the state government on or before 1/1/2006, at least for TDC Part 1, and where of the services of the teachers have not been provincial under the any act enacted by the state legislature so far. Then venture high school, same sentences, means high school imparting education up to class 10 and established by the people of the locality prior to 1/1/2006, and which has received permission from the state government and recognition from the Board of Secondary Education Assam on or before 1/1/2006, and whereof the services of the teachers have not been provincialized under the act enacted by the state legislature so far. Identically, for venture school, it is the permission, and JAD-A, that is very relevant in our case. Venture ME school includes venture ME madrasa, means an upper primary school imparting education from class 6 to class 8 and established by the people of the locality prior to 1/1/2006, which has received recognition from the competent authority on or before 1/1/2006 and captured the DICE code up to 2009-10, and whereof the services of the teachers have not been provincialized under any act enacted by the state, provided that the DICE code shall have to be issued on or before 2019, and DICE code issued thereafter shall not be considered for the purpose of provincialization of services of any employees of the institution. So in all these categories of institutions which are contemplated to be provincialized, like Venture Degree College, Venture High School, Venture Higher Secondary School, Venture Junior College, and Venture ME School, as well as JET-B is Venture Lower Primary School. Everywhere it has to be done in such a way that the local people have established the institution prior to 1/1/2006. And on that day, they must obtain the necessary permission, recognition, concurrence, and any other requirement on that day. So the act, while legislating, it was very clear that there is no scope of any subsequent order of giving a retrospective effect, of giving recognition, permission, concurrence, whatever. And it has been repeated throughout the act. It is not that in one place it has been stated. It has been stated in section 3 also. I'm coming to that now. Then JET-C is Venture Upper Primary Schools. Here also, it has to be obtained the permission of from the competent authority prior to on or before 1/1/2006. Then Venture Educational Institutions, that definition JET-D, it covers all those institutions. Now coming to section 3. What are the eligible criteria? And Lordship had raised a question regarding the amendment part of 2018 the other day. In fact, that amendment helped. There was no change of the cutoff date. The amendment provided that more schools can come into the realm of provincialization. The question is how? Earlier, the permission or recognition must be given to the highest class of the institution. By this amendment of 2018, the first class of the institution can also get it. So it has widened the scope of provincialization. It is to the interest of the institution or the writ petitioners. It is not detrimental to the institution. For that, Lordship will kindly come to the preamble part once more. Before going to section 3, what was the statement and objects of reasons of the amendment? In my book, Lordship, it is there of the 2018 amendment. In the compilation also, I am
You are showing the object of 17 Act or 18?
18 amendment part.
Yes.
The objective to introduce the bill, namely the Assam Educational Provincialization of Services of Teachers and Reorganization of Educational Institutions Amendment Bill 2018, to consider the degree colleges, senior secondary schools, erstwhile junior college, higher secondary schools, and high school, which have received permission for first year of HS school in respect of higher secondary school, concurrence for first year of HS school in respect of senior secondary school, erstwhile junior college, concurrence to TDC Part 1 in respect of degree college from the government, and recognition from the Board of Secondary Education for class 9 in respect of high school on or before 1/1/2006 for provincialization of the services of teachers and or tutors of these institutions under the Principal Act. So here, the first class was considered. That was the amendment. Now coming to section 3 now. In that section, both the provisions are stated here. Eligibility criteria for selection of educational institutions for provincialization of services of teachers, tutors. Subject to the
Just a minute, you are reading section 3
section 3.
of 18, 2018.
Yes, after the amendment. In the footnote, the previous provision is also quoted.
One minute. Which page you are reading from?
From this book,
Yes.
page 108. Only complaint regarding this book is that the footnotes, the size of the letters are very small. And I have to tell our honorable, our learned advocate, this is Chutia for this. It is very small. Indication of footnote. It cannot be smaller than this. May I read it?
He wants to test the eyesight of judges and the council.
Absolutely. He's torturing us. Or he should give a magnifying glass along with the book. The good,
Yes.
better quality.
Please proceed.
May I read it, Lordship? 3 is 1. Subject to the provisions of Article 30 of the Constitution of India, the following categories of venture educational institutions shall be eligible for being considered for provincialization of the services of the teachers and tutors. After the amendment, I am reading. The venture educational institutions which have been established and had obtained, Lordship will kindly mark this word, had obtained. In the definition, had received, that was the word used. Here, had obtained the required permission, recognition, affiliation, concurrence, as the case may be, required from the concerned institution from the respective competent authorities on or before 1/1/2006. Provided that the permission for first year higher secondary classes in respect of higher secondary school, concurrence for the first year HS class in respect of senior secondary school, erstwhile junior college, recognition from Board of Secondary Education Assam for class 9 in respect of high school, and concurrence of TDC Part 1 in respect of degree college received from the government on or before 1/1/2006 shall be treated as the permission, concurrence, recognition, as the case may be, for the purpose of provincialization of services of teachers and or tutors under this Act. Provided further that the order of such permission, recognition, and concurrence shall have to be issued on or before 1/1/2006, and other orders thereafter with retrospective effect shall not be considered for the purpose of provincialization of the services of any teachers or tutors, as the case may be, of the institution. So far as the second proviso, it was already there. It was already there. So now I am reading the prior to the amendment, what was there. It is at the footnote. Subject to clause 1 of subsection 1 of section 3 of the Assam Educational Provincialization Services and Reorganization of Education Institutions Amendment Act 2018, published in Assam Gazetted with 18th May. Note, before substitution of clause 1, read as the venture education institution which have been established and obtained the required permission, recognition, affiliation, concurrence, as the case may be, up to the last and highest class. This was the change actually. The last and highest class was the earlier requirement. Now we have started the first class. For the concerned institutions from the respective competent authority or authorities as on 1/1/2006. The proviso part, it was already there. Provided that the order of such permission, recognition, affiliation, concurrence shall have to be issued on or before 1/1/2006, or order issued thereafter for any retrospective effect shall not be considered for the purpose of provincialization of services of any teachers or tutors, as the case may be, of the institution. So the first proviso, there is a change. The second proviso, it has remained in toto. There was no change. So the amendment, in fact, has widened the scope of provincial. More institutions can come in. So there is no change of the cutoff date or regarding the sentence regarding retrospective effect. These are not changed. Nothing has been changed by the amendment. In fact, it is for betterment. It has given scope for more schools to come in, more institutions to come in. So this amendment part, there is absolutely no change except widening the scope of provincialization to various institutions who do not fulfill the criteria of the highest class or last class. This is the word, last and highest class, concurrence, because all this this recognition, permission, etc. are given class-wise. If the school from class 7 to 8, the 8 they will get a permission or recognition. Then 9, they will get permission and recognition. Every class, there is a requirement. Suppose a class 7 students or school, there may not be science laboratories. If they have to get the recognition, they must fulfill certain criteria. So each class, there is a special requirement while giving that. And number of students also is required, one of the parameter. So I am coming to the subsequent part. Regarding land, Roman 2, the land, building and other infrastructure of such venture education institution in case of venture shall be as per practicable with the provisions of RTE Act. So one of the submissions from the other side was that it is a conflict with RTE. There is absolutely, I have gone through the whole act today. There is rather, it is in consonance with the RTE Act regarding a people teachers ratio, regarding the infrastructural requirements, regarding the SMCs, etc. Everywhere it is in sync with the RTE Act. Or in the other case, the regulation of 2010, UGC regulation for the higher standard institutions. And rules framed thereunder, venture education institution in the case of venture secondary and higher secondary schools and junior colleges shall have to be as far as practicable at par with the provisions of Assam Non-Government Educational Institutions Regulation and Management Act 2006. This act also is in sync because although it act is of 2006, but it has certain provisions which are totally in sync with the 2009 RTE Act. But it's covered the higher classes also. And rules framed thereunder, and in case of degree colleges, same shall be as per the norms set by the UGC. Because the earlier round, Lordship, when the 2011 Act was set aside, from our side also we have said that yes, there is totally non-compliance of the various requirements under the NCT Act of 1993, UGC regulations of 2010, as well as the RTE Act, as well as the Assam secondary education rules. Everything was violated. So therefore, we take special care that there should not be any conflict or there should not be any dilution of the criteria which has been laid down in the state regulations as well as the central regulations. 3, the concerned venture education institutions must have land in the name of the institution with clear and exclusive title and possession over the land before 1/1/2006. So this date is not only for permission or concurrence or recognition. It is for various other aspects. And no lease or rent or donor agreement executed at any point of time shall be considered in the manner for this purpose. Then regarding tea garden land, etc. Then number 4, the venture education institution has a minimum total of 30 students if it is a venture primary or upper primary schools on the date of coming into force of this act. The venture education institution has a minimum total of enrollment of 25 students in class 10 if it is a venture high school, 25 students in class 12 if it is a venture higher secondary schools or venture junior college, 30 students in the final year of 3 years degree course if it is a venture degree college, as on the date of coming into force of this act. In case of venture high school and venture higher secondary school or venture junior college or venture degree college, the concerned venture education institution must have a consistent good academic performance, which would mean that at least 30% of the candidates appearing for the final examination as a whole must have passed in the last 3 consecutive examinations held during previous 3 consecutive years prior to the date of coming into force of this act. So we are giving a very lower
Just to pause you for a minute. We are trying to understand because this cutoff is a serious bone of contention.
Absolutely.
And probably the most
Yes,
contested.
Lordship.
Now, it appears to us that this proviso to section 3, of course, the first class, last card, that is another matter, is canvassing one thing. That say there are 2 institutions, venture institutions, both have been established before 1/1/2006.
Lordship.
Everything else is same. Both have applied for permission before 1/1/2006. One of them got it. The other somehow did not receive the permission from the authorities. It could be for various reasons. The state machinery acts in its own pace, and therefore it is possible that while one of them got the permission, the other did not. So is it the import of the statute You have not got it means you have not got it. You have missed out. Forget it.
It is like this.
Hmm.
Why they have not got it?
Why?
Why they have not got it? Because they have to fulfill certain criteria. If they do not fulfill it, that's why they did not get it. It is not a case that because of one of the submission from the other side is that there was a ban period. I'll place a lot of documents that during these all ban periods, lot of recognitions, permissions were granted. There was no such situation as ban period. Let them produce a single notification that there was a ban period. In some of the repetitions, they have said in November 2005 also.
That's fair enough. What you're
So
saying,
it is not a mechanical thing to get the recognition.
no,
Permission they can get.
that what you are saying may be correct, may be a situation, but that is a matter of verification of individual cases.
Absolutely, Lordship. That is a it will go to the single bench.
No, not on that.
But for that, the provisions cannot be faulted. The provisions of this act.
Mr. Saikia, it is necessary that there is complete clarity on,
Yes, Lordship.
as we have made it clear, your assisting counsels were there. We are going to examine the issues purely from the standpoint of
Constitutionally.
Yes,
Yes.
we are not on wisdom.
Absolutely.
Wisdom is not the ground. Now, one very heavy point canvassed by the petitioners counsel here is that while they are saying, all right, people who have not got the eligibility, not fulfill the norms before 1/1/2006, we understand. But there are a large number of venture schools who actually had fulfilled the norms before 1/1/2006. They had applied and all their applications were answered subsequent to 1/1/2006 insofar as the communication is concerned.
Yes.
The department did not communicate for various reasons, whatever may be the reason, which could be bona fide, not bona fide, we are not on that. So the argument is that when you completed the process, when the statute was in force, even the 2017 Act, forget the 2011, 2017 Act, then also the criteria was that within 1/1/2006, we must acquire the eligibility. Therefore, the receipt of approval can be before 1/1/2006 in some cases. In other cases, it may be after 1/1. But because there was a delay, this is not our fault. This is the department which has delayed it. So why should we be penalized?
Yes.
And particularly, you are creating two different categories of
Yes, Lordship.
schools.
I would like to answer.
That
this.
is the point. Yes.
I would like to answer. As it has fallen from Lordship's mouth, that some schools have got it and some did not. That clearly establishes that there was no ban period. Because somebody have got it
Mhm.
and they have not got it. When are they raising this grievance? They are raising the grievance at this stage. It is not a mechanical thing. You apply and you get it. You have to fulfill, there are verifications. There are certain criteria they have to fulfill. If they do not fulfill, will they get it? From the records I will place during my submission.
Mr. Saikia, again, at the cost of everybody, you may be correct on all those. We are not questioning it. We are on the principle.
I am on the principle. I am coming to the principle.
If the particular school has committed a fraud, mischief, whatever,
I am coming to that. Suppose, let the cutoff date be 1/1/2017.
you argue on the basis that everything is all right.
I'll argue.
Yes.
Cutoff date, if it is a cutoff date today, those who have got it till yesterday, they will be in advantageous position. Tomorrow, some schools are yet to get, they will be in a disadvantageous position. Whatever may be the cutoff date, there will be some group of people who will be aggrieved and some will get the benefit. We cannot escape that situation. Whatever may be the cutoff date. Government in this wisdom, after consulting with the experts and the financial conditions and other various parameters, came to a conclusion because government is under no obligations to provincialize them. Yes. So government said that 1/1/2006 will be the cutoff date. Whoever has acquired the quality criteria, they will come under the ambit of the provincialization. Otherwise, they will not come. if some school, let us come with some individual facts that I have fulfilled everything, yet I have not received. It is not only the 1/1/2006. They have to fulfill another criteria that they should be under the DIAS system of 2009 and 10.
That's fair.
There are
enough.
three criteria.
Sir, Mr. Sekia, sorry to again interrupt you. These arguments, nobody has any quarrel. What you are
No,
making.
no, because there are three parameters in the act. That's why I am saying that I have to place the whole act. It is not only 1/1/2006, 9/10, as well as 31st December 2010. The third date is by which an employee should be working. That they should complete 7 or 8 years as on 1/1/2017. So three criteria they have to fulfill. Everywhere there is a cutoff. There are three cutoff dates here, not only 1/1/2006. If 80 schools are getting the recognition prior to 1/1/2006 and 20 have got it after it, there may be some genuine reasons. It is not that government machinery was sitting idle. And so the chart, the writ petition number 7955. The chart will expose them. They got recognition first and permission later. These are all cases of fraud.
That you are entitled to
No,
take
no,
action.
that will definitely, Lordship. It is not that. Suppose cutoff date, whatever may be the cutoff date, 1/1/2000, let it 1/1/2010. The situation will be same.
That's not the point. Point is not.
And I'm arguing on the legal
On the
principles.
principles.
I'll place a Supreme Court judgment on this. That there has to be a cutoff date.
Yes.
And how the cutoff date will be finalized, we have to look at our financial condition. In the act itself, we have stated that a separate fund will be created. It is a huge expenditure, Lordship. It is not a very easy thing. Section 22 for a time moment.
Section 22.
22 of this act,
Yes.
creation of fund. The state government shall create a special pool of fund to facilitate implementation of the provisions of this act in consultation with the finance department of the government of Assam in due course of time. It is not that it is a very easy exercise. It is not a regular fund that can be utilized for this purpose. A special fund has been created or is to be created. It was created already, Lordship. But it has a meaning. Why this provision is inserted here? We can do it till today. But the whole economy will crumble.
Nobody is questioning your cutoff date.
Then then nothing remains, Lordship.
Where the issue they are arguing and we are trying to understand is, they are saying in implementing the cutoff date.
That is an individual case. That will be an individual case.
Correct.
In that case, the single judge will definitely look into it, that it was the fault of the authorities or whether it was the fault of the school. Whether in these batches of cases, Lordship will look individually.
So are you saying that in all cases where the delay in communication of the recognition is because of fault of individual?
Now, one very interesting case. I have gone through the writ petition as well as our
No,
affidavit.
Mr. Sekar, we are asking questions because we are trying to
Yes,
understand.
Lordship, and I am also trying to assist this honorable court.
Correct.
In the writ petitions, they have combined the schools together. All have different factual positions.
We have noticed that.
Lordship has noticed that. Whether that is maintainable.
We will deal with it.
Because we have to have an issue where we have to attack. They raise the issue, then we have to give a counter. Now, which individual school, because of the fault of the government, they did not get the recognition? We have to know that first. Just making them submission and trying to convince this honorable court
We
will
agree,
not do.
we agree with you.
We have to deal with factually.
We agree.
The
with-
facts should be before this honorable court so that counter facts will also come.
No, we agree with what you are saying. So are you saying that in those cases where the delay is on account of governments, if let's assume that there is a delay on account of the government's some kind of a laches or negligence, are you saying that in those cases the stringency of this cutoff date will not be applicable.
No, for that, a judicial order has to be passed individually
All right,
by assessing the factual position. Lordship will give us an opportunity, will give, handle
certainly.
a particular, suppose X school.
Mm.
It was the fault of the government, the education department.
Mm.
In that case, Lordship will hear education department also. Their only submission will not do. Education department will also come with its own story. That why that notification was not issued regarding the permission prior to 1/1/2006. But just making a blanket submission,
You are saying there could be
individual case.
individual facts.
Yes, Lordship. That's why it will go before the single judge. Lordship is looking in a broader aspect. So whether the government has done the right thing in fixing a cutoff date or not.
No,
Whether
the government is entitled to fix a cutoff.
that is what I am trying to satisfy this honorable court. If that is the case, I don't have to argue.
That cutoff date the government can fix. The only question is by fixing the cutoff date and by implementing it in a manner, does it infringe upon the fundamental rights?
If
of
individual, if suppose, if somebody is aggrieved, a hardship has been caused by that date, he will have to satisfy this honorable court by citing his individual factual position.
No, but if the proviso, the prescription of this, just a minute. Mr. Saikia, you see, at the cost of this is a very important critical point in this entire batch of litigations. Therefore, we are
No,
trying to ensure that there is
Actually,
no-
I have prepared only this point only today.
See, I'm
I will open all my cards.
speaking,
One by
no,
one.
no, you open your cards, you open your everything, but speaking for the bench,
Lordship.
I'm trying to put the debate in the correct perspective. Nobody is questioning, and we are also not entertaining any such plea that the government could not have put a cutoff date. That's not anybody's case. And that can't be anybody's case. These are matters of policy. Policy matters, the courts will not have
Absolutely.
any
Lordship.
opinion to render. We are also
Those are
not
my
going to-
cards.
We are not going to do it.
Yes.
At least basic understanding of
Yes,
the
yes, Lord.
constitution.
These are settled position.
The only question we will examine here, and we will examine, is that is the cutoff date being implemented differentially so as to give advantage to one group of schools while denying the benefit which had already accrued to the other group of school merely on a fortuitous
So Lordship is,
circumstance.
yes, Lordship is just
the
saying
government
that
is-
whether there is a discrimination.
That's the only
Yeah.
point, nothing else.
Now, to cite a case of discrimination,
Yes.
they have to first establish that they are discriminated. They have to
They are
say,
saying the statute is discriminatory.
how can it be?
You argue on that.
How can it be? My submission would be, it cannot be discriminatory. Because we have, in every sentence, we have said that suppose there is an advertisement for employment. 31st October is the last date of submission of application. And you have to acquire your graduation or whatever qualification is asked for.
Correct.
Somebody has not got it on that day. So that cutoff date will remain. On that day, he is not eligible. Here also, I am saying, I'll place from the records that this concurrence, permission, recognition will not come automatically. Whether they were actually eligible to get the recognition or permission or concurrence on 1/1/2006. Just for 1 second, Lordship. This, affidavit অনুবা এখন দিছে না এখন এনেকে দিছে না
Yes.
this chart in our affidavit filed in 7955.
Just a minute. We have to take it out.
এখানে মনে হয় এটা স্যার রেকগনিশন পাইছে I'll just cite two examples from this.
WPC
one chart.
7955
55.
2000.
2017 আচ্ছা এইখন উলিয়াই দিছো
What is it, 17 or 19? Perhaps it is 2019, Mr. Sekya. WPC 7955.
Dwarka.
2019. All right, doesn't matter. Mr. Majumdar, can you tell us the date of the affidavit?
Filed on.
With 67 over. $67. No, it is available, no? Any example of this?
You know, conclude by, before lunch.
Only one point, because this cutoff, that is the main point.
That is the main point, yes.
That is the main point. And in the writ petition also, Lordship will kindly see. Lordship will kindly take 7955, page 67. The recognition section.
But it is a formidable point, Mr. Sekya. It's a
Now,
formidable
what
point.
I am trying to say that only page 67, have Lordship got it? The
Page
writ petition.
Page 67 of the writ petition.
Page 67 of the writ petition. Then I will come to the affidavit.
Yes.
Page 67, Lordship will kindly see the school that is Lokhipur. Serial number 30, 20. It will give 29. Gosai Dubi Girls ME School, Madrasa.
Just a minute. And in this manner, they will
Can be reviewed or review.
All right, Mr. Sekya,
Lordship.
just to put the debate in proper perspective, because
Lot.
there has been some gap in between. You are free to argue the way you want,
Yes.
obviously you are free. But we want to put a few flags here that certain things are not in our domain. We are not concerned about it. For example, this is a welfare legislation. The state could have done away with it. That's none of our business. Whether the state wanted to do, didn't want to do, we are not going to.
No,
examine
we
it.
have done it. So your lordship will look into it from the concept.
We will only see, as mentioned earlier, that whether challenge made to any of the provisions of the statute offends the constitutional provisions. That's the only thing. If you don't bring it, you don't bring it. But having brought it,
I understand,
you
lordship.
cannot say that.
No,
don't do this.
what I am in the preamble, it
Correct.
is not only
Correct.
one
This-
part is provincialization, the other part is to check,
Correct.
third part is to ensure proper compliance.
Correct.
Three objectives we have.
This is one facet. This is one facet. We understand that the state, for whatever reason, has been generous here and has taken all these provincial venture schools, embraced them into the
We
system.
have to streamline the
That-
whole
that's-
education
that's
system.
understandable.
Hmm.
But the problem for this court is that our duty is only to examine the constitutional validity, not the wisdom, the mechanism. We are not going into that. We are not competent to say anything on that. So we will
No,
not.
but I have to apprise it.
You
What are the
apprise.
circumstances?
You apprise.
What is the intention of the legislature?
Background, as a background.
Yes, I have to.
You do it. Second point is, just flagging the main issues here. Vociferously, arguments have been made in case of tutors.
I'm coming.
No.
First is cutoff, then tutors, then objective, RTE
Correct.
conflict,
So on tutors,
music teachers, all this.
Tutor-
I'll deal every aspect.
you deal with it. On tutor, as we can recollect, the argument has been that, or rather the prelude to the argument is that whether if these people are not eligible, whether they should have been brought in or brought out, that's not the point. Point is, having made them government servants, can you keep them in a fixed pay for lifelong? That's the argument. The answer could be yes, the answer could be no. So you kindly address on that, not that the government could have ignored them, not brought them. This you can argue, but then in our judgments, those things may not have much of a relevance. We will only see whether these argument that this is unconstitutional has got any legs to stand. So the point of your reference may kindly be on those.
And then I have, this lordship had the other day
Correct.
spelled out, even section 24. All this, I have noted it.
All right.
I'll deal every aspect. Now, page 67
Page 67, yes.
of the repetition.
Yes, please.
Lordship will kindly take, because I'm going to give some instances that 1 month prior, 2 months prior to 2006, recognitions were being granted. Here, serial number 20, I'm not sure, but name is Lakhipur, third one from top. Gosai Dubi Girls ME School. If Lordship will look into their date of permission is 19/6/1992 and date of recognition is 14/12/2005.
Yes.
Then next school also, Lordship will kindly see. Permission is of 19/12/2005. And recognition is of 28/2/2005. So the school first got recognition and later on got the permission, which is upside down. Anyway, but what I am trying to emphasize is that just before 1/1/2006, so schools were getting recognition, permission, etc. Now coming to next page. In case of three schools, Borbila ME, the recognition was obtained on 28/12/2005. Then next is Baudi Dubi Bilpari, that is also 29/12. Then another school, Jingrampara ME School, 28/12/2005. Coming to next page again, Lordship. The recognition was obtained on 14/12/2005, 12/1/2005, 28/2/2005, 29/12/2005. So all these schools, they have covered. It is not that all of a sudden 1/1/2006 was fixed.
You are saying possibility of foul play is writ large.
No, I am not on record. There's submission that there was a ban period from 1992 to 2005. That is not correct. I think they were trying to impress this honorable court that 10 years in the repetition they have stated.
Yes, yes.
So all these were getting the permissions, recognitions during that period. So it is not a correct fact. We have very categorically denied this. There was no ban period at all.
All right.
Now, the affidavit says, if Lordship is pleased to take the
Yes,
affidavit here. Let me place the act first, then I will come to the affidavits.
All right.
But what I am trying to emphasize is that cutoff, prior to the cutoff date also, lot of schools have got this opportunity.
You want to first refer to the act?
Hmm?
First, you want to refer to the act?
Yes, act.
Yes.
Then section 3, eligibility criteria, I placed up to Roman 4. Roman 5 also, there is a criteria regarding the number of students to be enrolled in various schools. Then the performance, 30% performance. Now 7. For provincialization of services of one teacher or tutor, as the case may be, in each subject, including the core subject in case of Venture High School, Venture High Madrasa School, Venture Higher Secondary Schools, and Venture Senior School, at least 10 students must have appeared in the last final examination in that particular subject from the institution. Pausing here for a moment. The other day, one of the submissions was made that only 3 teachers can be taken. 3 teachers can be provincial. It is no, there is no upper cap in that. That is why I'm placing the scheme. So, in each subject, if there are 10 students who have appeared in the last examination, that subject will be included. If there are 10 such subjects, that school will have the science, English, and the general studies apart from these individual subjects also. There can be 13 teachers to be provincialized. It is not limited to 3. So there is no upper cap. But there should be student in that subject.
That is only a condition.
That is only a condition. If there is no student, suppose music teacher, there are no music teacher students or 1 or 2 students are there. For that, 1 teacher is not allowed. We have fixed a criteria that minimum 10 students, and which is on a much lower side. Reading further, at least 10 must have appeared in the last final in the particular subject. Further, for provincial service, a maximum number limit of 3 teachers or tutors in a particular school, as the case may be. In case of venture degree, at least 15 students in that particular subject must have appeared in the last final examination. In 8, in case of venture ME school, there must be 1 science teacher or tutor to teach science and mathematics subject. In case of Venture High School, there must be 1 teacher or tutor in each core subject, mathematics, science, English, ML, and social studies. For provincial service of additional teachers or tutors, as the case may be, for a particular subject, including the core subject, in addition to the post mentioned in section 3.1 Roman 7, which I have just placed, in any venture school or venture high madrasa or venture higher secondary school or venture senior secondary school, the minimum students appearing the last final examination of the highest class of the said school for that particular subject must exceed 80 for 1 additional post and 150 for the 2nd additional post. Further, for provincialization of services of additional teachers or tutors, as the case may be, for a particular subject, in addition to the post mentioned in 3.1.7 in a venture degree college, the minimum students appearing in the last final examination of the highest class for that particular subject must be more than 150 for 1 additional post. 10. 2 number of teachers or tutors of the venture LP school shall be provincialized under this act, and their services shall be merged with the base school identified in respect of the area wherein the venture school was situated. After so merger in the base school, the minimum number of teachers as specified in the schedule of RTA Act 2009 shall be followed. The deficit in number of posts of teachers in the base school shall be filled up in accordance with the norms and standard of the said act and following the provisions of relevant act and rules in force for filling up the vacant post. So we are not in conflict with this act, rather it is supplementing. 11, in case of venture upper primary school, there shall be minimum 3 teachers or tutors or at least 1 teacher in each science, mathematics, social studies and languages. Provided for additional posts, it shall be considered in accordance with the norms and standards stipulated in the schedule under section 19 and 25 of the RTE Act 2009. Then enrollment part. 12. The enrollment shall be verified from the data as per DICE code of 2019 or before as available in the records of the National University of Educational Planning and Administration, New Delhi. There shall be physical verification of students and checking of records of attendance of students of last 3 years. Then Lordship will kindly come to 2 and 3. This is regarding the UGC norms, the fulfillment of these criteria. Then base school. How the base school will be selected, various criteria are laid down here. Then 10. If any eligible venture education institution intends to remain outside the purview of provincialization of services of their teachers or tutors under this act, such institutions shall give their option in writing, expressing their intention to remain outside the purview of this act before the district scrutiny committee within a year from the date of coming into force of this act. So many schools may not opt for provincialization. So they can remain outside. But they have to come under the another act of 2007. That private school act is there. So they have to register it under that. Like the DPS school, Don Bosco, St. Mary's, all these missionary schools or the Jatiya Vidyalaya schools, they also do not come under the provincialization scheme. So that option, that is why the one objective is to streamline the educational institutions. For that purpose, this provision has been inserted. Now 4, teachers or tutors to be government servant. Subject to fulfillment of all other provisions of this act, the services of the teachers or tutors of the venture education institutions eligible under section 3 shall be deemed to have been provincialized on the date of publication of the provincialization order by notification in the official gazette, and they shall become employees of the state government with effect from such date. The teachers or tutors to be provincial under this act must have been working as a teacher of the concerned venture institution as mentioned in section 311 that have been recognized by the competent authority on or before 1/1/2006. That is number 1. Next is Lordship. Must have minimum educational and professional qualification as laid under different acts, regulations, as mentioned under section 6 or any other relevant statutory provisions as the case may be. 3 is important, Lordship. Must be rendered at least 6 years continuous service as on 1/1/2017. This is another cutoff date, Lordship, here. From the date of joining in the concerned venture education institutions, which must be on 31/12/2010 or prior to that date. So those individual teachers who want recognition or the provincialization, they have to fulfill this criteria. Their institution got getting permission, recognition, that is a different chapter. But they also have to give service of 6 years. So there is a cutoff date, 31/10/2010, they should be in service or prior to that. That means 6 years qualifying service. Now, in case of the other subjects, Roman 4, in case of teachers or tutors of the school for special subjects like Sanskrit, Arabic, Hindi, craft teacher, music teacher, and other classical teachers, the number of students appeared in the concerned final examination like HSLC or higher secondary H+10+2 conducted by the SEBA or the Assam Higher Secondary Council as the case may be, shall not be less than 10 students in each class per year during the last 3 years. So we can increase the number of teachers to be provincialization, but there are certain parameters they have to fulfill. The precondition is that 3 students, 1 teachers, no. 10 students must be there. They have to be there continuously for 3 years. Then land and building to be vested with government. Then educational and professional qualification section 6. Here, Lordship will kindly see. Next page. The regulations which are to be complied with, that is RTE Act of 2009, National Council of Teachers Education 1993, Assam Secondary Education Professional Service Rule 2003, amended in 2012, UGC regulations of 2000, Act of 1956, and the regulations made thereunder of 2010. All these criteria has to be fulfilled. Because of non-compliance of these provisions, Lordship, the Act of 2011 was set aside by this Honorable Court. So there is no conflict, Lordship, with these state acts as well as the central acts. The services of the teaching employee in a venture education shall be considered for provincialization as teachers only if they have the requisite academic and professional qualifications as prescribed under the relevant act, rules and regulations as mentioned in subsection 1 of this section, which are applicable for the time being in force. Otherwise, their service shall be provincialized as tutor. In case of teachers of special subjects like Sanskrit, Arabic, Hindi, etc., the qualification should be as per the qualification prescribed by the relevant statutory rules of the state government in force. Then educational and professional qualification for tutor. I'd like to read out this. The tutor must acquire the prescribed educational and professional qualification within a period of 5 years from the date of publication of the order of provincialization of services of the teachers and tutors of the concerned venture education institutions in the official gazette. And after acquirement of the required qualification, they shall be upgraded to the post of teachers in appropriate cadre. If such teachers fail to acquire such prescribed qualification within a period of 5 years from the date of publication of the order of provincialization in the official gazette, their cases shall not be considered for upgradation to the post of teachers after a lapse of 5 years from the date of publication of the provincialization order in the official gazette, and they shall continue to function as tutor as per same terms and conditions which are applicable to them before the provincialization of the concerned venture educational institutions. So they will continue to be like that. So 5 years leeway is given to them to acquire the qualification, and they can be upgraded to teachers or any post like the professor, assistant professors of the highest. But if they fail to do it within 5 years, then they will continue. It cannot be a never-ending process. Then terms and conditions. Roman 3 is relating to, 8, section 8, subsection 3 is relating to tutors. Basically, the same thing is repeated here. Then 9 is management of institutions managing committee as per the RT Act of the School Management Committee, section 10. Then the governing body of the other acts are also taken care of. Then section 12, amalgamation, merger and shifting and expansion of education institution. That there are various other schemes going on of merging schools, amalgamation, etc. Those are also considered here. Now, section 13 is important. District Scrutiny Committee and State Level Scrutiny Committee. There shall be a District Scrutiny Committee in each district separately for elementary, secondary, and for higher education to scrutinize service records and other related issues of the serving teachers of venture education institutions pertaining to provincialization of their services. The Deputy Commissioner of the district by an order shall constitute the District Scrutiny Committee for the respective districts under the preceding subsection. Provided in case of newly created district, the Deputy Commissioner of the erstwhile district with the help of Deputy Commissioner of the newly created district shall scrutinize all cases of the entire erstwhile district. Who will constitute the District Scrutiny Committee for Higher Education shall be considered of following members. There are 6 members here. Then Roman 4 says District Scrutiny for Secondary, identify the personnel who will be part of the District Scrutiny Committee. Now, how they will function, section 6 says, subsection 6 says, the District Scrutiny Committee shall first scrutinize and prepare a list of all venture education institutions within the district which are eligible in terms of the provisions of this act and shall thereafter proceed to scrutinize and verify the service records of all the serving teachers who are eligible or would be eligible for being considered for provincialization of their services. The district committee shall identify a base school for each school, each category of school and recommend the name of the teachers or tutors to be associated against each base school. The district scrutiny committee shall forward a verified list of eligible teachers base school wise in accordance with this act to the concerned director, who shall place the matter before the state level scrutiny committee to be constituted under subsection 10 of this section. And after making such further enquiry as may be required, shall forward the same to the concerned department of the state government for consideration and for issuing notification in respect of the eligible institutions and teachers eligible for getting their services provincialized. The district scrutiny committee shall have the power to inspect physical existence of schools and to inspect all documents and records produced before it, and call for such further records and documents as may be required for the purpose of causing verification and scrutiny, and examine witnesses for the purpose if considered necessary. And while doing so, it shall have the power of a civil court for the purpose of compelling attendance of persons and production of documents. The state government may, for reasons to be recorded in writing by an order, reconstitute the district level committee or may change its composition if the circumstances so warrant from time to time. Now, there is a scope for state level committee. There shall be one state level scrutiny committee at state level for verification of recommendations received from the district scrutiny committee with the following members: the director of the concerned department of education as chairman, joint director, deputy director of the concerned director as member secretary, one representative nominated by the concerned administrative department as member. The state level scrutiny committee shall have to cause physical verification of all institutions and will inspect the documents and records produced before it and call for such other records and documents as may be required for the purpose of causing verification. When there arises differences in between the recommendation of the district scrutiny committee and the physical verification report caused by the state level committee, the matter may be placed before the state level committee and the decision of the state level committee shall be final. For the purpose of this section, the deputy commission in relation to district, including the areas covered under the 6th schedule of the Constitution of India, shall mean the principal secretary of the respective councils. Appellate authority. The state level scrutiny committee shall be the appellate authority against any recommendation of the district level committee, and the state government, in case of the concerned administrative department, shall be the appellate authority against the recommendation of the state level committee. So there is a structure is there. Section 15. Educational institutions not provincialized to function as private non-government institution. The services of the teachers of the venture educational institutions which have been established on or after 1/1/2006 shall not be provincialized, and no such educational institution shall be allowed to remain functional unless it has obtained affiliation from the affiliating university, if it is a degree college, permission under the provisions of the Assam Non-Government Educational Institutions Regulation and Management Act 2006 in case of other educational institutions. And 3, certificate of recognition from the authority notified under the provisions of Section 18 of the RTE Act 2009. All such venture educational institutions which have obtained the required affiliation, permission, or recognition, as the case may be, shall be allowed to function as purely private and non-government educational institutions. So the Act has also considered the institutions which are established after 1/1/2006. The overall objective is to streamline the educational system. There cannot be any casual business regarding this educational institution. Then offenses, etc. Then creation of fund, I have already placed lordship, section 22. Now coming to section 24, repeal and saving. The Assam Venture Educational Institutions Provincial Act 2011, as amended in 2012 and 13, have been struck down by the Honorable Guwahati High Court by order dated 23/9/2016 in WPC 3190/2012. And all rules, orders, notification issued thereunder shall stand repealed. However, all the teachers whose services were provincialized prior to 23/9/2016 shall continue, and their cases shall be reviewed as per the eligibility norms set forth for the provincialization under this act. So I'll make that my submission on this at a later stage. Now cut off date first. Regarding the cutoff date, Lordship, in two affidavits, we have taken very categorical stand. If Lordship is pleased to take the affidavits,
Affidavit filed in 7955
7955 by Pritam Khoikia, that affidavit. Two affidavits here.
Yes, one is 11/5/2018. Dated. Are you referring to that?
One is May 2018, the date.
Yes, 11th May 2018.
Yes. Paragraph 3 onwards, Lordship, I'd like to place.
Yes.
The instant writ petition has been filed challenging the proviso to section 311 of the Assam Province Act 2017, whereby it is provided that the order of permission, recognition, affiliation, concurrence shall be issued on or before 1/1/2006, and any order issued thereafter with any retrospective effect shall not be considered for the purpose of provincialization of services of any teachers or tutors, as the case may be in the institute. As per the said proviso, the present writ petitioner schools, madrasas would not come under the zone of consideration for such provincialization, as because all the orders of recognition of the petitioner's schools, madrasas issued particularly on 15/1/2006, 15/2/2006, 8/28/2006, 7/6/2006, and 15/6/2006, respectively, by giving retrospective effect of 1/1/2005 and 1/1/2006. And as such, even after fulfilling all the criteria, they would be deprived of from the benefit of provincialization of their services due to the aforementioned proviso of 311. The deponent begs to say the government, by taking a policy decision, have set the cutoff date for grant of permission recognition as 1/1/2006 in respect of the venture education institutions which are to be considered for provincialization, and incorporated the same under section 311 of the Assam Educational Provincial Act 2017, and the said act has been passed by the Parliament Assembly on with effect from 5/5/2017. Paragraph 5. The deponent begs to state that the rationale behind stipulation of the cutoff date for grant of permission / recognition to the non-government educational institution is to curb the unplanned and mushroom growth of non-government educational institutions at the primary, secondary, and higher secondary levels in the urban and semi-urban areas of the state. Moreover, such mushroom growth of such non-government educational institutions have necessitated the state to make laws to regulate the establishment and management of all the non-government educational institutions. Example, educational institutions established and run by individuals, association of individual society, or trust at primary, secondary, and higher secondary level without receiving any grant in aid or financial assistance from the government. Moreover, the deponent begs to state that as it is observed that there is an increasing trend of commercialization of education, and many educational institutions have been established with the sole motive of earning profit with scant regard to the standard norms of land, building, classroom, furniture, library, laboratory, etc., fire safety, playground, etc. The teaching and non-teaching staffs are paid meager salary, and their services are terminated or dismissed on flimsy grounds without giving reasonable opportunity to defend themselves. The state government at times have to remain a silent spectator in spite of large-scale resentments expressed by the public. As such, it is expedient to provide for law to regulate the establishment and management of all the non-government educational institutions functioning in the state and those to be established in future. However, the deponent begs to state that keeping such objectives in mind, the state legislature way back in January 2007 has framed the Assam Non-Government Educational Institutions Regulation and Management Act 2006, which came into force on 19th January 2007. Therefore, as there are enough government schools, I'm repeating, as there are enough government schools to cater the need of students in the state and to impart them adequate mandatory education till the age of 14. Therefore, no such schools are at present required so as to maintain the people-teachers ratio. Moreover, the thought of the government is to raise the standard of the government schools, and in order to maintain the quality of the schools, the quantity of such schools need to be controlled by curbing the mushrooming growth of such educational institutions, as enrollment to such schools are very less, and if the growth is not controlled by giving a cut-off date, there would be more teachers in schools than the students, and every household will become a school. In fact, this is the ground reality. 3 brothers, 3 schools in one compound. These are the findings of our committees. 3 brothers have 3 separate schools. The deponent begs to state that since the cutoff date as incorporated in the Act as on 1/1/2006 is a policy decision of the government, the same may not be interfered with by this honorable court, as no arbitrariness or malafide has been alleged by the petitioners, incorporated the date as such. In fact, may I pause here for a moment? Except there are about 70-80 petitions, except one petition, there is no challenge to the cutoff date. And that was also filed because in the first round of arguments, at the time of interim hearing, we made a full-length hearing. We made the submission, there is no challenge to cutoff date. Then that's as a second afterthought, that petition sprung up. In fact, all other petitions, there is no challenge to this provision, cutoff date. These are all afterthoughts after hearing our submissions. The same may not be in the so and so, as there is no arbitrary or malafide has been alleged by the petitioner, which incorporated the date as such. It is only their personal inconvenience for which the same has been put to challenge, which should not be interfered with this by this honorable court. Any personal inconvenience may well be addressed by the petitioner before the respective tribunal of their districts, and for that the provisions of that shall not be interfered with. The date as incorporated has been made with proper application of mind, taking into consideration the various aspects of the matter by the expert, and as such, simple inconvenience to the petitioners would not render the cutoff date arbitrary to be interfered with by this honorable court. Pausing here for a moment once again, there are a series of cases in education department where for getting the financial assistance, the Dias code date was required. Lot of schools have come before this honorable court and they did not submit lot of documents at the relevant point of time, and they are not entitled for getting the grant in aid, maybe in 2012 onwards till 2016-17. This honorable court interfered and directed that post-dated Dias code may be issued to them. That can be one way of looking into it, but that will not make the requirement of Dias code arbitrary or illegal, Lordship. The same thing can be applied here also. If suppose a particular school has all the things and it is the fault of the authorities, then that can be individual.
You say a case-based stand can be taken.
Case-based, and they have to establish it, they have to satisfy. That's why in our affidavit we have said, if individual grievance is there, the district level scrutiny committee, state level scrutiny committee, that's why I placed the whole act. If the district level committee is not giving favorable order, they can challenge before the state level committee.
No, but the problem is unless, as long as the act remains the way it is, in the sense that 1126/2006, nobody is seriously challenging that. Cutoff date is not seriously under challenge. Although 1 or 2 petitions.
Then Lordship, they have to
The point
first,
is, we were
if they are
in
not
existence-
challenging, then that may not be considered by this honorable
No,
court.
the challenge is to proviso to amended act of 2018.
Amended, where is the problem, Lordship? That has expanded the area. What is the amendment?
Second proviso.
Second proviso is already there in the first, before amendment also it was there. It was there in 2017 Act in its first inception, in its first form. The amendment part only changed from the highest class to the first class.
Let us have a look at it once again.
Yes. Amendment has not changed any language. Second proviso has remained intact. If Lordship is pleased to take the book.
Yes, please.
Second proviso, earlier also it is the same word, not a single change in the word. Subsequent after amendment also the second proviso remained intact.
Mm.
And have Lordship got it. Only the first proviso there is an amendment.
So yes, you are right. Three proviso to section 3 and in the sequel, the amended provision, both are under challenge here. On the ground that the communication of the concurrence has to be received before 1/1/2006.
That was there from day one.
That's correct, but that's also.
So amendment of 2018 has not changed the position. Rather, it has changed the position in respect of more schools can come into the consideration for provincialization. Some schools may not have the last class concurrence. They may have the first. So now the first class concurrence is also eligible for provincialization. So it has widened, it has given more benefit now.
That's right.
And so far as a second provider, there is absolutely no change. It is in ditto, verbatim.
So you do agree that in principle, can we take it that if there is a genuine case where.
They have to establish, they have to individually come, not jointly.
Correct.
The Bengali school of Paltan Bazar may have a different situation like Panbajar High School of Panbajar. Every school has their own story, own individual factual matrix. So they cannot join. So that is why all these schools, some schools have everything prior to 112. They are also joined here. They have also joined. They have other grievances, but Lordship will have to look in, and for that we have to individually give affidavit. But that will not make the provisions of cutoff here arbitrary or illegal. It is not discriminatory, neither it is in violation of any constitutional mandate.
No.
Now coming to the third affidavit.
Yes.
This is an affidavit in 6548 of 2019.
Can you give me the file, please? 6548.
May I continue with the same repetition? There is second affidavit also.
Second.
Then I'll come to the third one. 7955 of 2017. Paragraph 4. Paragraph 4. That with regard to the
Yes.
that with regards to the content in paragraph 2, the deponent states that the petitioner schools are not similarly situated, and thus they are not entitled to prefer this writ petition jointly. It is stated that the following table will present a clear picture of the status of the schools. The first is Dwarka ME School. It was established in 1994. Permission was granted on 9/1/2006. So the first step to establish a school,
Yes.
they have to get the permission. I get the permission, then I run the school for few years. Then I will request for the recognition. Lordship will kindly take note of the date. 9/1/2006, by order dated 9/1/2006, they got the permission. Now recognition part, Lordship will come to the right hand side. 1/1/2006, by order dated 15/5/2006, they got the recognition. So prior to getting permission, they got recognition.
Right. These are-
So will Lordship allow these schools writ petition to maybe
Certain-
maintain?
These are all individual. Yes.
So Whatever we can brought it to the record, we are bringing. Next, Lordship will kindly see. KC Borman Memorial ME School, 11/12/1992, it was established. Permission obtained on 22/11/2005. And recognition 1/1/2005 by order dated 22/28/2000. So the school was established, got the permission in the month of November in 2005. And they got the recognition from 1st January 2005, 11 months prior. These are fraud played with this honorable court. Third one, Vidyapit ME Madrasa. Permission was obtained in 2006 by order dated 7/1/2006. And recognition is they have received on 1/1/2006. So 7 days earlier. Third case of fraud. Numerous instances will come out, Lordship. These cannot be clubbed together. All these cases are totally different. Each individual will have to come and will have to get the opportunity to give them the counter. So their status, some schools are genuine here also. It is not that all the schools, 43 numbers to club together, they do not have the same status. Some have played fraud, some are genuine.
You're arguing on misgender of cause of action.
Absolutely. On technical ground. Now coming to after the chart, may I read it? Thus, it is relevant to note that in most of the cases, the recognition of the schools has been given effect prior to even the effective date of permission granted to the school. And one very interesting point, Lordship. All these schools were established somewhere in 1992, 94, 86. Lordship will see first 4. School was established in 1994, then 1992, then 1996, then 1986. What were they doing? Permission was to be taken at that point of time also. So why they waited for 20, 25 long years to apply for permission? We cannot have undue sympathy for these kind of institutions. So may I read it, Lordship? Thus, it is relevant to note that in most of the cases, the recognition to the school has been given effect to even prior to the effective date of permission granted to the school. It is further stated that the petitioner schools did not raise any grievance as and when they were awarded permission and recognition. It was only now that they are raising a grievance. So from 2005-06 also till 2017, this petition was filed. They had no grievance. It is further stated that as per the annexure attached to the writ petition itself, several schools have been afforded permission to establish the school after 1/1/2006. The orders granting recognition to the different schools are matter of record, and it is seen that in each of the orders, certain conditions were affixed. The petitioners have not made any statement that the conditions laid down for grant of such temporary recognition has been fulfilled by the schools. So these are basically provisional recognition also, because they have to fulfill certain criteria regarding number of students, regarding the educational facilities, regarding the infrastructure. So they are silent. The writ petition was filed on 13/12/2000, laying the challenge to the so and so. The affidavit in opposition was filed by the department on 11/5/2018. Subsequently, the said provision of law has gone an amendment and been substituted as per notification of 16 May 2018 with immediate effect. The petitioners have filed an affidavit reply on 29/2019 to the affidavit in opposition filed by the deponent. In the said affidavit, the petitioners have referred to certain minutes of the meeting dated 12/9/2018, and in the said meeting also discussions were held regarding the implementation of the 2018 Act. The petitioners therefore had the knowledge of the aforesaid amendment, but has chosen not to put up any challenge to the same. These exhibits the lackadaisical attitude of the petitioners in pursuing their case. It is thus submitted that the present writ petition deserves to be dismissed in. They have not challenged 2018 amendment, but it is to their benefit. The answering deponent stated that it has already been established in the foregoing paragraph that most schools have been afforded the opening permission after 1/1/2006, and the school accepted without any protest, and thus there can be no truth in the assertion of the petitioners that the schools ought to have been recognized by an order prior to 1/1/2006, even when the opening permission itself was granted after 1/1/2006. It is further evident that in certain cases, the recognition was given effect to even prior to the date of opening permission. In such view of the matter, it is submitted a present petition deserves to be dismissed with cost. The deponent further states that the Assam Venture Educational Provincial Act 2011 are no longer applicable. Further, as per the provisions of the 2017 NEC, the cases of the services of all the teachers who were provincialized prior to 23/9/2016 shall be reviewed as per the eligibility norms set down in the 2017 Act. Now coming to the third affidavit law. Here the dice code aspect is also highlighted. What could it be?
Third affidavit is in another.
Okay, Lordship, the third affidavit, we have filed it in 6548 of 2019, and that case they have withdrawn recently. Acha, they have taken it to a single judge's bench. They have given up the challenge regarding the provisions of the Act. So, but our affidavit will cover certain aspects of this case. So if Lordship allows, then I'd like to place it. We have extra copies also.
The writ petition is not there.
Not here,
You can make your oral submission, or you can incorporate in the written submission.
but I'll read it out because that will give the actual official version.
Correct.
My verbal submission is always not better than these official statements. No, in this case,
We may not be able to agree with that.
and then certain things, Lordship, when it is stated by the official person's Lordship, because education, there are a lot of facts. Every officer has his own way of giving
Maybe,
affidavit.
but submission of the learned.
Then
advocate
I
is-
understand, Lordship. I am not onto that. Maybe my friend would have also argued. The thing is that, Lordship, we have seen every officers have their own mindset. So whatever is stated there, it is official. So we have to consider it. There are a lot of subjective thinkings in the education department, not unlike the other departments. Paragraph 7 of this. It is regarding the DIAS code. What is the importance of DIAS code? Because many schools will not qualify under DIAS code because they do not have DIAS code in 2009 and 10. In 2011, when the Act came, the first provincial Act, then they started applying.
Followed.
Paragraph 7, the answering deponent states that the petitioner have admitted that they have been captured in the district information system of education. That is the full form of DIAS. On and from the year 2010-11, we wanted 19. It is stated herein that the process of capturing schools in the DIAS code was introduced from the year 2006 and 7 onwards in Assam. It's a national phenomenon. It's a pan-India exercise. The procedure for capturing under the DIAS system was all schools which are previously captured under the DIAS system are issued data capture form by the cluster coordinators under the Sarva Shiksha Abhijan, and such forms are submitted back to the coordinators within 30th September of a particular year. So these cluster coordinators, they distributed the forms, and by 30th September, everybody has to give it back by filling in all the particulars. The data is then processed for correction and variations, and steps are taken for having the data furnished by the school to be uploaded in the national portal for that particular year. In case of new schools or school which were not captured in the DIAS data in the previous year, such forms are collected by the schools and the information is supplied to the coordinator, who again take necessary steps for having the school captured in the DIAS data. It is therefore evident that the schools of the petitioners were either not functioning at the relevant point of time or had failed to provide the data to the concerned authorities for maintaining the record, and as such, they are not captured in the DIAS system for the year 2009 and 10. It is further stated that the DIAS data once uploaded in the national portal cannot be rectified, and allotment of DIAS code for previous year is also not permissible. It is stated that DIAS data in the national portal system is uploaded annually, and DIAS data for 11th year cannot be granted. The answering deponent state that as per records furnished by the petitioner, the schools have received financial assistance for the year 2011. And thereafter, in fact, some cases the schools have opened their bank account in the year 2010-11. The answering deponent state that the effect of the enactment of Assam Venture Educational Provisions Act 2011 are matter of record. The striking down of this paragraph is not relevant. In paragraph 10. With the striking down of the Act of 2011, all provisions of the Act, including the definitions, have been struck down. It is further stated the government is framing the 2017. In framing the 2017 Act, had decided to introduce Section 2 JADE to define venture ME schools by laying down certain norms for the purpose of the Act. The insistence of the cutoff date of 1/1/2006 and having received DIAS code on or before 2019 is a policy decision of the government to enable it to give practical effect of the Act of 2017. Allotting a DIAS code to the school has been in practice from the year 2006-7, and there has been, and the responsibility of having applied for grant of DIAS code rested on the respective school. The principal aim of the Act was not only to provincialize the service of the teachers of venture educational institutions as defined in the Act, but also to reorganize and streamline the educational institutions up to degree level. It is stated that provincialization of venture educational institutions involve financial, administrative, and several other considerations. It is stated that keeping all conditions, that is economic condition, financial condition, and other attending circumstances, it was decided that the schools which have been captured in DIAS code till the year 2019 and had received recognition, etc., as applicable prior to 1/1/2000, prior to or on 1/1/2006 was taken up for provincialization. It is relevant to state that while many schools have not furnished the information for inclusion in the DIAS code till the year 2019, several schools have taken action to obtain DIAS code for the year 2019 onwards, basically on two accounts. Firstly, to be eligible to draw financial assistance, and number two, on the notification of the 2011 Act. It is also noticed that the 2011 Act had laid down a criteria for considering only those institutions which have received recognition up to 1/1/2006 and had captured the DIAS code up to 2019. So 2011 Act also had the same criteria. We have not changed that criteria also. So 2011 Act, 1/1/2006 and 2019 DIAS code captured. 2017 same, and 2018 amendment also same. There is no change of the position of the government. Because that 1/1/2006 was considered by taking into consideration basically the financial situation. It's a huge, it's a mammoth expenditure of the government. It is not a small amount also. We do not want the economy to get any adverse effect regarding other developmental works also. The answering deponent state that the schools of the petition do not fall within the definition of venture ME school as given in Section 2 JADE of the Act of 2017. In fact, as stated above, the petitioner 5, 6, and 8 do not fulfill either of the conditions, that is recognition by order passed on or before 1/1/2006 and on being captured in the DIAS data of 2019. It is denied that the DIAS quota for 2019 is not available due to negligence on the part of any official. Rather, it is apparently due to the negligence on the part of the authorities of the petitioner's schools to divulge information to the concerned authorities for inclusion in the DIAS data. Paragraph 16. Even the provisions of Section 2 JADE require that the school should have been captured in the DIAS Code in 2019, it is stated here that the right of children to free and compulsory education Act 2009 was brought into force with effect from 1/4/2010, and in the said act, a particular definition of school, child and elementary education amongst others as given. The said act also brought a provision for establishing or continuing the functioning of a school. The erstwhile Act of 2011 also laid down the criteria of having Dias Code up to the year 2019, forming consideration for provincialization. Therefore, the fixation of the condition for being captured in Dias Code for the year 2019 is not arbitrary or illegal. It is also stated that the schools which have captured in the Dias Code up to 2019 and schools which obtained Dias Code for the first time in 2010-11 form two separate and distinct classes for the purpose of the Act of 2017. The ratio of setting up a cutoff date of eligibility is based on several factors, and thus same cannot be either unreasonable, arbitrary, or capricious. Paragraph 17. The deponent states that the petitioner in the state petition have asserted that the schools were established in the year 1995, have land in their name and were accorded departmental opening permission, got recognition and financial assistance, and therefore the insistence of having Dias Code for the year 2010 is ultra vires. The aforesaid contention of the petition are wholly baseless, and since the eligibility criteria of having captured the Dias Code in the year 2019 is well considered decision arrived at after duly considering several factors such as economic viability, financial burden, administrative exercise, and other conditions. The aim of the Act of 2017 cannot be construed to provincialize the services of the teachers of each and every school. Rather, it is to consider provincialization of those schools which met the criteria laid down by the Act. The answering deponent state that there is no inherent right among the petitioners to seek provincialization in any form. It cannot be the case of the petitioners that they had participated in the activities in the schools in issue for the last 20-25 years in the hope of provincialization, where on one hand, statements have been made that the schools were established since no other schools were operating. There, on the other hand, an argument is sought to be made that they have worked for 20-25 years without salary or income, only in the hope that someday some law would be enacted to provincialize their services. Apparently, the petitioners are challenging the provisions of the Act only because they may be put to suffer inconvenience since they do not fulfill the conditions laid down in the Act of 2017. It is stated that at no point of time did the petitioners raise any grievance regarding non-receipt of Dias Code for the period prior to 2009 and 10. Then coming to paragraph 21. It is, however, apparent from the pleadings itself that while on the one hand, the petitioners claim in paragraph 4 of the petition that the schools were established in the year 1991, 88, 85, 79, 1990, 88, 85, 1990, and 1992. The applications for permissions were made subsequently. The applications for permissions was made subsequently. There, on the other hand, they claim that the schools were started after obtaining permission. There was apparently contradictory statements. The petitioners have also not asserted that they fulfill the conditions laid down in the order granting them temporary recognition. All the schools were not recognized by order issued prior to 1/1/2006. All the schools are not identically placed, and thus they are also not eligible to prefer present representation in a joint manner. The petitioners did not take appropriate steps for being captured in Dias Code in 2019, and thus they are not entitled to raise any grievance regarding the requirement of such code at this stage. So basically, these are the three affidavits on the cutoff date relating to recognition permission 1/1/2006 and as well as the Dias Code 2009-2010. These three affidavits will cover this situation. Now, my submission regarding the cutoff date is that, Lordship, everybody cannot be satisfied by giving a fact cutoff date. There will be some persons who may have a heartburn because of the fixation of the cutoff date. When we give a cutoff date, that means on that day, they must fulfill all the eligibility criteria. whether it is for the purpose of employment, whether it is for the purpose of admission in any school or institution, or whether it is for the purpose of provincialization. For MBBS examination also, for admission of the medical college also, there is a cutoff date that on that day they have to obtain the qualification. For job also, when an advertisement is issued, there is a last date of submission of application. Identically, in case of provincialization also, on that day, we said that the permission as well as recognition must be issued on or before 2006. If somebody has failed to obtain that on that day, they are not eligible. It is as simple as that. I may get PhD degree tomorrow. Today is the last date. I get it after 1 week. Whether that will be sufficient to consider my application for any job. Provisional thing is not permissible, Lordship. And the act is very categorical. And Lordship has seen the instance. Recognition is granted, most of the cases, recognition, those who have come before this honorable court. There are maybe 70 petitions or 50 petitions, but 80-90% schools are getting the benefit. A small segment is aggrieved because they do not fulfill. We have doubt whether those schools were actually functioning or not. Why they have not registered under the DIAS code in 2019 if the school was established way back in 1986? That is the reason that mushroom growth of schools we have to curb. We have to streamline the existing educational institutions. The 2000 Act, registration under the Act of Private Schools Act, which is also put to challenge, but till now, these 3 rounds of hearing have taken place. This honorable court did not grant any relief till now. Some of the petitions are being withdrawn now, including DPS challenged that thing. So we want the registration of the schools. We want that the proper schools with proper qualified teachers are giving or imparting education to the tiny tots and the other students. Intention of the government is very clear. Those who are actually doing the work of imparting education, providing education to the people, they will get the benefit. Those who are eyeing for getting some government fund without discharging the duty, which is envisaged, they are not entitled. If your school was established in 1986, why you have applied for the permission in 2005 or 2006 and recognition thereafter? That shows the sincerity, integrity of those persons who are behind these schools. Schools are run by individuals or group of individuals or societies or trust. We have to look into that. And government, after a lot of threadbare discussion, came to this conclusion. Those who are genuinely doing it, they are getting the benefit. There is no quarrel about that. That's why we filed a review application, because when we have regularized or provincialized, sorry, not, I'm using the wrong word. When we have provincialized under the 2011 Act, 43,000 teachers were getting the benefit. Out of 43, 35,000 to 40,000, they were genuine. They fulfill all the requirements. Rest remaining 3,000-4,000, because of which the whole act crumbled. So because of that, we filed a review, and in section 24, we have inserted that provision that will revise their credentials. We will look into their credentials. So the purpose of this act is that those who are genuinely providing education and establishing and running schools, they will get the benefit. And those who are doing some fraudulent act, mischievous act, they will not get the benefit. Their own pleadings is proving that. I don't have to borrow any other facts. Their own pleadings on oath, they have filed the affidavit and they have filed the writ petitions. The facts they have stated clearly demonstrates that something is terribly wrong. Maybe some of our officials are involved. That is why the legislature very prudently taken a decision that no retrospective orders will be considered. If the school was perfect on 1/1/2006, what is the business of giving that order after 6 months or after 1 year, after 2 years, after 3 years? With retrospective effect. That is not contemplated in administrative law. That you can give retrospective effect. This honorable court always can do that. Give it from the date of such and such. Even when a act is set aside, it is always it is retrospective, unless there is a direction from this honorable court that prospectively all actions will be set aside. That is the normal thing. But some officers, the government is aware that these kind of orders are there. That is why, with a proper application of mind, that particular proviso at the very first instance in 2017 said that no orders with retrospective will be considered for provincialization. Lordship knows so many officers of education departments are behind bar during that period. So it is not that everybody is very clean, but we have to run the system because these are part of the system. With time, it will fade away, but till now, we still apprehend that there can be some mischievous orders. That is why that proviso was deliberately inserted. It is not accidental. That's why I placed those facts that in the month of November, in the month of December 2005, recognition orders were issued and they have placed it. That means it was a continuous process. It was not that after 1/1/2006, all these orders were issued. Their own schools, which are part of the writ petition, or they are part of the writ proceedings, they themselves have obtained those things. So it is not correct to blame everything to the education department because somebody has got it on 11th of December, somebody got it on 28th of December. How they have got it? Because they have fulfilled the criteria of recognition. Let them produce the order, full orders. What is actually written in that recognition order? These are provisional. In our affidavit, we have stated that provisionally recognition orders were given. Actually, that is also irregular. I'll not use the word illegal. That is why when a recognition order is there, the school is already in function. After the permission, they can run the school. But to get the recognition, they have to fulfill all the criteria. And when the criteria are fulfilled, after due inspection, the recognition order is to be issued. That means when the provisional recognition order is issued, that clearly establishes the fact that those conditions are not fulfilled on that particular date. If it was not fulfilled on 1/1/2006, by order of June 2006, he cannot give a retrospective effect of 1/1/2006 or prior thereto. Because on that particular date, 1/1/2006 or prior to 1/1/2006, all the criteria were not fulfilled. So let each individual school come and will verify those. The intention of the government did not have that thing, that we want to discard this school. It is not pick and choose or there are some blue-eyed schools to the government. We fix the criteria. If you fall into that criteria, you will get the benefit. Otherwise, it is not. They can still continue if they are so dedicated for imparting education and providing education to the people. They can still run. There is no bar. The provision is there in the act itself. They can continue as a private institution, but they have to register under a separate act, which is being done by most of the good schools. Those who are actual intention is to provide education, not to get government fund. That is
Mr. Saikia, have you?
now.
Just a minute, have you granted any, have you provincialized any school under the 2017 Act?
That information, Lordship, I can give the figure also, those who have got the benefit. It has been done. That exercise has started.
Then how it is done? What about the 1/1/2006 cutoff date?
We had that for so many schools have qualified. There is no stay order of this act.
Please understand the question of stay doesn't arise, but You said only those schools which were established and got the recognition before 1/1/2006. They will only be provincialized
Yes.
under the Act of 2007. Correct. Now, when the act was set aside, those who were already provincialized before the setting aside of the act, that has been saved by 24, section 24.
As well as a review order.
Right. There are many who are before us saying that in our case, everything was complete. Say, for example, there is a crafts teachers matter.
Yes.
Mr. Manish Goswami, I think, is arguing in that case. There he has demonstrated that these teachers, 206 of them, the scrutiny committee has examined them, made a recommendation. It was pending final notification by the government prior to 1/1/2006. But at that time, this act got struck off. And the new act comes, so that brings in a criteria of 1/1/2006. Therefore, they are agreed to that extent. Now, if the statute prescribes that nobody can be given, nobody can be provincialized unless recognized and established before 1/1/2006, then by the time 2017 Act came, it is about 11 years. So for 11 years, these schools have not been provincialized. Or they were recognized subsequent to 1/1/2006.
I'm not very clear about the query, but my submission is very clear that if somebody was left out to be provincialized under the 2011 Act,
Only they were provincialized.
no, others also. The scrutiny committee, state level scrutiny, everybody is in job. They are doing.
So schools established after 1/1/2006 have
No,
also.
prior. Those who fulfill the criteria laid down in the 2017 Act, they are being considered.
That
And
was-
lot of tutors are also being regularized. Tutors. They came, there are separate other petitions also pending, where
Right.
they want as a pay scale or enhancement, all these issues are pending.
All right, so that means.
So we have already acted upon 2017 Act.
All right, so under 2017 Act, all these schools which are provincialized, all of them have been set up before 1/1/2006.
Yes, that is the
They
criteria.
have got the recognition before 1/1/2006.
Sorry, I'm good not getting last line.
What we are asking.
Yes.
You may take instructions
No, no.
if necessary.
Whoever have got the
You can-
benefit.
Then give us the response.
No, no,
afterwards.
no, right now I am giving.
Hmm.
Those who have got the benefit of provincialization either under 2011 Act or under 2017 Act, they have fulfilled strictly all the criteria laid down in 2017 Act.
Mr. Saikya, the question is slightly different. We are asking you, after the 2017 Act came into being, has any school been provincialized which was set up after 1/1/2006?
No, no,
No.
straight no, Lordship. How can we do it? We cannot violate our own act. No, absolutely no.
Has any school been recognized after which was set up after 1/1/2006?
I am sure it can, because it's a continuous process. Only for getting benefit of provincial under this act, that criteria is there. But the exercise for even without provincialization act,
They can continue.
it was always, it's a continuous process. Permission, recognition, concurrence, approval, all are part of this system
So only
from 1955.
provincialization, this will come into.
This criteria we have taken so that we have to select some parameters has to be set in. This system was there from 1955. There was no scope of provincial at that point of time. Even for private schools also, suppose tomorrow I want to start a DPS, I have to take permission, I have to take recognition.
Correct.
So this system will continue. Tomorrow I want to take advantage of this, then I will not fulfill the criteria because my recognition, my permission is after 1/1/2006. The government is not violating Lordship.
Yeah, understood.
Unless Lordship interferes, then we have to.
No, that's good. We'll see.
So I would like to place few judgments because there are various implications if the cutoff date, because if they are challenging cutoff date, if they are serious about it, then I have to place the judgments. Otherwise, those who fulfill the particular criteria of eligibility to be considered for provincial and under 2017 Act Lordship, they have to, because the word had obtained, if Lordship please takes up this section 3 once more.
Yes.
Section 3, eligibility criteria for selection of education institution, provincialization of services of teachers, tutors, subject to the provisions of Article 30 of the Constitution of India. The following categories of venture education institutions shall be eligible to be considered for provincialization of the services of their teachers and tutors. The venture educational institution who have been established and had obtained. Every word has a meaning, Lordship. And had obtained the required permission, recognition, affiliation, concurrence, as the case may be required for the concerned institution from the respective competent authority or authorities on or before 1/1/2006. And if we look to the other part, to the definition part also,
Yes.
suppose taking the example of JADE, Venture ME School. Same language is used in every institution. JADE, Venture ME School, including Venture ME Madrasa, means upper primary schools imparting education from class 6 to class 8 and established by the people of the locality prior to 1/1/2006, which has received recognition from the competent authority on or before 1/1/2006. So received also must be 1/1 before. Retrospective effect order after 1/16 will not cover. So deliberately the intention of the legislature is very clear, loud and clear, Lordship. There is no ambiguity. That those who have acquired the qualification or the requirements or the eligibility parameters as on 1/1/2000, they will come under the ambit of this act. Identically for the Dias Code also. So had obtained, very deliberately that word has been inserted there. So now coming to, I would like to place 3-4 judgments on the cutoff date. Yeah. Yes. Hold on.
Yes.
I would like to place 4 or 5 judgments, Lordship. One is Dalit Chanda versus 2005 9 SCC, page 779.
Paragraph.
The Dolly Chanda versus Chairman JE, 2005 9 SCC, page 779, paragraph 6. Paragraph 7. The general rule is that while applying for any course of study or post, a person must possess the eligibility qualification on the last date fixed for such purpose, either in the admission brochure or in the application form, as the case may be, unless there is an express proviso to the contrary. There can be no relaxation in this regard in the matter of holding the requisite eligibility qualification on the date fixed. This has been established by producing the necessary certificates, degrees, and mark sheets. Similarly, in order to avail the benefit of reservation or weightage, etc., necessary certificates have to be produced. These are documents in the nature of proof of holding a particular qualification or percentage of marks secured or entitlement to benefit of reservation. Depending upon the facts of a case, there can be some relaxation in the matter of submission of proof, and it will not be proper to apply any rigid principle as it pertains to the domain of procedure. Every infraction of the rule relating to submission of proof need to not necessarily result in rejection of the candidate. In our case, the recognition as well as the permission are the dates. On that day, it has to be issued. It's a recent judgment, 2022 SCC online, page 425. Shekhar and another versus National Board of Examination. This is by a 3 judges bench comprising of the Honorable CJI. Paragraph 12, Lordship. Cut-off date আরো ভালো judgment ছিল। Get up, well, bro. Only 10 to 12. Let us.
Yes.
Paragraph 12, Lordship. Whenever a cutoff date is extended, some students are likely to fall on the other side of the dividing line. In the state of Bihar versus Ramji Prasad, the state had prescribed the applicants applying for the post of assistant professor must have 3 years of experience. In the preceding year, the cutoff date for the receipt of application was set in June. However, in the year in question, the date was fixed in January, making certain candidates ineligible owing to their failure to meet with the 3 years requirement. This court held that the cutoff date cannot be held to be arbitrary unless it is shown that it is unreasonable, capricious, or whimsical, even if no reasons are forthcoming as to the choice of the date. This court observed thus, in the present case, as pointed out earlier, the past practice was to fix the last date for receipt of application a month or 1.5 months after the date of actual publication of the advertisement. Following the past practice, the state government fixed the last date of the receipt of application as 31st January 1988. Those who had completed the required experience of 3 years on that date were therefore eligible to apply for the post in question. The respondents and some of the interveners who are not completing the required experience by that date therefore challenge the fixation of the last date as arbitrary and violative of Article 14 of the Constitution. It is obvious that in fixing the last date as January 31st, 1988, the state government had not only followed the past practice, and if the High Court's attention had been invited to this fact, it would perhaps have refused to interfere, since its interference is based on erroneous belief that the past practice was to fix 30th January of the relevant year as the last date of receipt of application. Except for learning on the past practice, the High Court has not assigned any reasons for its choice of the date. As pointed out by this court, the choice of date cannot be dubbed as arbitrary even if no particular reason is forthcoming for the same, unless it is shown to be capricious or whimsical or wide off the reasonable mark. The choice of the date for advertising the post had to depend on several factors, that is, number of vacancies in different disciplines, the need to fill up the post, the availability of candidates, etc. It is not the case of anyone that experienced candidates were not available in the sufficient number on the cutoff date, merely because the respondents and some others would qualify for appointment if the last date of receipt of application is shifted from January 31st, 1988 to 30th January 1988, is no reasons for dubbing the earlier date as arbitrary or irrational. We are therefore of the opinion that the High Court was clearly in error in striking down the government's action in fixing the last date for receipt of application as 31st January 1988 as arbitrary. In our case, although in not very specific term, but we have said that various factors we have taken into consideration: economic condition, financial burden, and implementation of the act. If we give all the leeway to all the schools, ultimately the scheme will fail. Will not be able to sustain the economy, the funding position, Lordship, because it huge expenditure.
Yeah, understood.
So that factor we have to consider. That is why Section 24 is there. A special fund has been created in consultation with Finance Department. We want to give benefit, but we have a limited budget. The pocket is not a very big one. So the next judgment, 2000, 6 SCC, 2005 6 SCC 754. State of Punjab versus Amarnath Goel and others.
Six SCC page.
754.
Paragraph.
Paragraph 26 to 37.
Yes,
May I read it, Lordship?
yes.
It is difficult to accede to the argument of behalf of the employees that the decision of the central government, state governments to limit the benefit only to the employees who retire or die on or after 1/4/1995, after calculating the financial implications thereon, were either irrational or arbitrary. Financial and economic implications are very relevant and germane for any policy decision touching the administration of the government at the center or at the state level. Even by the OM dated 1910-1993, all that happened was that a portion of the dearness allowance linked to average consumer price index of 729 obtained as on 1/3/1988 was treated as dearness pay. This would count only for reckoning the emoluments for the purpose of calculating retirement cum death gratuity under the applicable rules and for no other purpose. This change was brought into effect from 16/9/1993. Even at that time, interestingly, the benefits were not made admissible from 1/3/1988, that is the date of average consumer price index of 729.91. But from a much further date, that is 16/9/1993, the central government adopted the same policy by issuing OM dated 14/7/1995. Although dearness allowance linked to the All India Consumer Price Index of so-and-so was treated as reckonable part of dearness allowance for the purpose of calculating DCRG gratuity, the benefit was actually made available to the employees who retired or died on or after 1/4/1995. Similarly, the increase in the ceiling of gratuity was a mere consequential step, which was also made applicable from 1/4/1995. As we have noticed, 1/4/1995 was the date suggested by the Fifth Pay Commission in its interim report. The central government took a conscious stand that the consequential financial burden would be unbearable. It therefore chose to taper down the financial burden by making the benefit available only from 1/4/1995. It is right that the final recommendation of the pay commissions were not ipso facto binding on the government, as the government had to accept and implement the recommendation of the pay commission consistent with its financial position. This is precisely what the government did. Such an action of the part of the government can neither be characterized as irrational nor as arbitrary, so as to infringe Article 14 of the Constitution. And skip paragraph 19, DS Nakara's case. In DS Nakara, which is mainstay of the case of employees whose arose special circumstances quite different from the present one, it was a case of revision of pensionary benefits and classification of pensioners into two groups by drawing a cutoff line and granting the revised pensionary benefit to employees retiring on or after cutoff date. The criterion made applicable were being in service and retiring subsequent to the specified date. This court held that for being eligible for liberalized pension scheme, the application of such a criteria is violative of Article 14 of the Constitution, as it was both arbitrary and discriminatory in nature. The reason given by the court was that the employee who retired prior to a specified date, those who retired thereafter formed one class of pensioners. The attempt to classify them into separate classes group for the purpose of pensionary benefits was not founded on any intelligible differential, which had a rational basis nexus with the object sought to be achieved. However, it must be noted that even in cases of pension, subsequent judgment of this court have considerably watered down the rigid view taken in DS Nakara, and we shall later on in TN electricity case. In any event, this is not a case for a continuing benefit like pension. It is one-time benefit like gratuity. In Union of India versus PN Menon, while implementing the recommendation of a third pay commission with regard to dearness pay linked with average index level, which was to be counted as emolument for pension and gratuity under the central services Pension Rules 1972, the central government had fixed a certain cutoff date and directed that only officers retiring on or after the specified date were entitled to the benefit of the dearness pay being counted on for the purpose of retirement benefit. This was challenged as arbitrary and violative of Article 14 of the Constitution. This court turned down the challenge and observed, not only in matters of revising the pensionary benefits, but even in respect of revision of scales of pay cutoff date on some rational and reasonable basis has to be fixed for extending the benefit. This can be illustrated. The government decides to revise the pay scale of its employees and fixes the first day of January of the next year for implementing the same, or the first day of January of the last year. In either case, a big section of the employees are bound to miss the said revision of the scale of pay having superannuated before that day. An employee who has retired on 31st December of the year in question will miss that pay scale only by a day, which may affect his pensionary benefits throughout his life. No scheme can be held to be foolproof so as to cover and keep in view all persons who were at one time in active service. As such, the concern of the court should only be, while examining any such grievance, to see as to whether a particular date for extending a particular benefit or scheme has to be fixed, an objective and rational consideration. In Action Committee South Eastern Railways Pensioners versus Union of India, it was held that on merger of the part of dearness allowance as dearness pay on average price index at 272 with reference to different pay ranges, fixing a cutoff date in such matter was not arbitrary and the principle enunciated in DS Nakara was not applicable. In this connection, the ratio in Krishna Kumar, etc., cases are apt. In all these cases, prescription of a cutoff date for implementation of such benefit was held not to be arbitrary, irrational, or violative of Article 14 of the Constitution. The importance of considering financial implication while providing benefit for employees has to be noted by this court in numerous judgments, including the following two cases. In State of Rajasthan versus Amritlal Gandhi, this court went so far as to note that financial impact of making the regulations retrospective can be sole consideration while fixing cutoff date. In our opinion, it cannot be said that this cutoff date was fixed arbitrarily or without any reason. The High Court was clearly in error in allowing the writ petitions and substituting the date 1/1/1986 to 1/1/1990. More recently, in Viraswamy, this court observed that financial constraint could be a valid ground for introducing a cutoff date while implementing a pension scheme on revised basis. In that case, the pension scheme applied differently to persons who had retired from service before 1/7/1986 and those who were in employment on the said date. It was held that they could not be treated alike and they did not belong to one class and they formed separate classes. In the state of Punjab versus Bhutta Singh, after considering several judgments of this court in DS Nakara to KL Rathi, it was held that DS Nakara should not be implemented to mean that the emoluments of person who retired after notified date holding the same status must be treated as the same. In the state of Punjab versus JL Gupta, where one of us was the bench Sabarwal, the view expressed in Bhutta Singh was reiterated and it was held that the grant of additional benefits which had financial implications, the prescription of a future date of conferment of the additional could not be considered arbitrary. In Ramrao versus All India Backward Classes case, a division bench of this court said even for the purpose of effecting promotion, fixing a cutoff date was neither arbitrary, unreasonable, nor did it offend Article 14 of the Constitution. Moreover, the court held that the possible hardship to be endured by a person as a result did not make the cutoff date violative of Article 14. In the instant case before, the cutoff date has been fixed as 1/4/1995 on a very valid ground, namely that of financial constraint. Consequently, we reject the contention that fixing of the cutoff date was arbitrary, irrational, and had no rational basis, and it offends Article 14. So my submission is, Lordship, purely on financial condition that date was fixed. It could have been 1/1/2010 also, but we have to know what is our budget and up to what extent we can provide the benefits. What is provincial? We have to provide the salaries and other and also. Very clearly, we have stated in our act itself. So may I conclude today and continue tomorrow, Lordship? Because second half also there is a reference also.
But we have no other matter in the list.
then because I'll not be able to finish in 1 hour because I have several other aspects to be.
All right, then you want to continue tomorrow?
Yes, Lordship. I want to finish it off.
Rather a single bench. All right, tomorrow.